Okay. Before we begin, we would like to go over a few housekeeping notes. This session is being recorded. The slides and recording of today's webinar will be provided in a follow-up communication. Please use the Q&A button at the bottom of your screen to submit your questions at any point of today's session. We'll be addressing these at the end of the presentation, and we will do our best to get to all of them. Okay. On behalf of Baker McKenzie and the IMT Group, welcome to and thank you for joining today's webinar, Asia Pacific IMT webinar series, Customs Audit in Malaysia, Trends and Tips. Co-chair of the Asia Pacific Industrials, Manufacturing and Transportation Industry Group of Baker McKenzie, based in Tokyo. As you notice, customs issues are something very important, but at the same time, sometimes unpredictable, especially in Southeast Asia. Not a few companies with a big presence in this region get into trouble with customs authorities, and this trend has been even worsened by the fact that the governments are financially struggling because they had to take various measures to respond to the pandemic. Malaysia is not an exception, and our colleagues from Malaysia today will explain the recent trend and how to manage the situation. I'm pleased to be joined by Jason Lian, Kelvin Hon, and Wei-Lit Won from Won & Partners, a member of Baker McKenzie International in Kuala Lumpur. Jason is a partner in the Tax, Trade and Wealth Management Practice Group of Won & Partners. His focus is on tax disputes and controversies, with experience in handling all aspects of tax litigation. He regularly appears before the national courts and tax tribunals, representing clients on landmark tax disputes and precedent-setting cases. Kelvin is a senior associate in the Tax, Trade and Wealth Management Practice Group of Won & Partners. His practice focuses on various trade, customs and corporate regulatory issues along the supply chain, including customs audits and disputes, setting up of regional distribution hubs, supply chain restructuring and optimization, satisfaction of rules of origin under the free trade agreements, FTA enforcement, tariff classification, and so on. Wei-Lit is a legal assistant in the tax and trade practice in the Tax, Trade and Wealth Management Practice Group of Won & Partners. Wei-Lit focuses on particularly on international trade and compliance, including advising on accessing the Malaysian market in aspects of tax, customs, and technical barriers. And now I will hand over to Jason, who will kick us off with today's presentation. Jason?
Thank you, Hodaka-san. Welcome, everyone. So first off, I'd like to cover some key business and legal trends in Malaysia, just to cover them briefly because we only have about an hour. And to start off today's webinar, we'll start off with key business trends. I want to share what we have witnessed, especially from engagements with our clients in Malaysia and what we've been hearing and working together with some of our clients. First, we certainly have noticed that Malaysia is becoming quite a popular destination for companies to set up their regional hubs. There definitely is an increased interest, at the very least from the clients, if not plans put in place to commit to actually setting up regional hubs in Malaysia. Businesses are doing so really with the goal of to actively expand, acquire, or even construct regional distribution centers and warehouses in Malaysia. Second, we are also seeing a shift in the distribution formats across different industries, such as the removal of intermediaries between manufacturers and consumers. And what we see really is driving this is pressure for increasing profit margins. This is definitely driving a shift in the mentality in terms of how they want to treat this distribution formats in Malaysia. Third, of course, would be the COVID-19 pandemic. Certainly has impacted all of us across any industries, regardless of your location. And this has prompted quite a number of companies to diversify their supply chains and to really with the goal of increasing resilience of their supply chains, as well as to try to produce goods closer to their end markets, their targeted end markets. Now, in practice, what we have been seeing is various supply chain securitization measures, and they range from diversifying supplier portfolios or even acquiring suppliers through vertical acquisitions. And lastly, we are also seeing an increased amount of emphasis on pressure on businesses to actually invest in sustainability and the environment. In fact, actually, this from a policy point of view as well, we certainly are seeing the Malaysian government encouraging this. They are introducing various incentives related to the EV industry. Beyond the automotive front, we are also seeing more guidance and frameworks being issued by the government for sustainable energy producers in Malaysia. Right. Next slide, please. Now, there are several key legal trends following. They may and actually mostly follow business trends, but based on what we are seeing, we are certainly seeing an increased amount of awareness in ESG in Malaysia. ESG being environment, social, and governance. And this is definitely aligning with recent business trends in promoting sustainability. From a legal point of view, the Malaysian government has actually declared that they're planning to introduce policies and regulations which have quote unquote ESG values. So by way of example, Malaysia has recently launched a voluntary carbon market to control carbon emissions. And they have certainly announced their plans to introduce carbon tax as well, which is actually quite a hot topic at the moment. Second, Malaysia has been and will continue to be an active participant in free trade pacts or free trade agreements, right? Malaysia is a member of the RCEP, the Regional Comprehensive Economic Partnership Agreement. Malaysia is also a member of the CPTPP, right, which is actually in the midst of ratification process, which I believe is expected to be completed within 2022. That was actually the declaration. Kelvin can confirm that. But these trade pacts will actually, what we are seeing is elimination of most tariffs on imports between signatories. It will certainly make it less costly for Malaysian manufacturers to source export materials, etc. Thirdly, on a more domestic front and enforcement front, we are seeing that the customs are becoming a lot more aggressive, as per Hodaka-san's comment earlier, pertaining to audits or even dawn rates. These are the topics that we'll focus on and cover a lot in significant detail today. And for obvious reasons, right? The government's priority really is to restore revenue streams after the whole host of stimulus measures to really cope with the pandemic. What does it mean in practice then? Well, it just simply means that audits will increase, right? They will become a lot more routine and they will become a lot more thorough. And furthermore, as we all know, the authorities, the tax collection agencies in Malaysia, they publicly declare their collection targets. They do have collection targets, and audits will simply assist them towards achieving that goal. Now, lastly, and actually very much complementary to the audit measures that the Malaysian government will be taking, there is a shift towards self-compliance, more emphasis towards self-compliance. From the government's perspective, tax compliance really is the quickest way to increase revenue collections using relatively limited resources. This would save costs arising from enforcement-related measures, contentious audits, and litigation proceedings. One very good example is the Malaysian government introducing tax compliance certificates. What this tax compliance certificate is, it's a cert that is a prerequisite. You need this before you can tender for government projects. So this is a measure which purports to promote businesses to conduct extensive internal due diligence just to ensure that there is compliance with respective companies. There is also a launch by the Malaysian government with respect to voluntary disclosure and amnesty program. And this is something that we'll discuss in further detail during our presentation today. All in all, what we can see is both from a business and a legal trend, Malaysia is keeping up to speed with global trends. It remains a competitive market in Malaysia. It remains a competitive market in the ASEAN region, and we are not seeing any particular breaks being put in any ways towards progressing towards that goal. So I think I will pause there and hand it over to Kelvin.
Thanks, Jason.
Yeah.
So moving on to the next segment of the presentation, what we want to do is to cover the nuts and bolts of a customs audit process. And hopefully this will give you sort of a bird's eye view of what are the various moving components that underpins a customs audit process. So if you're a legal counsel, a trade compliance manager, or an indirect tax manager, you sort of have these information to help you navigate through the customs audit process in the event of an audit. So a quick introduction to the key authority that undertakes the audit, that will be the Royal Malaysian Customs Department. Now, the Royal Malaysian Customs Department is headquartered at Putrajaya, but the way they sort of roll out the enforcement is at state-level branches. So, example, in Penang, you would have a branch. In Klang, you would have a branch looking after the whole of Selangor. And the interaction between the two entities is that Putrajaya sets the policy. State-level branch rolls out the implementation of these policies and rolls out certain enforcement measure that is set centrally at Putrajaya. Now, in the context of a customs audit, it's important to sort of note the interaction between HQ as well as the state-level branch, because any customs audit involving an amount more than 3 million would actually require some level of supervision or collaboration by customs headquarters in Putrajaya. Now, on this slide over here, what we wanted to share to sort of kickstart the presentation is a couple of statistics. So in 2021, the government actually has set a 40 billion collection target, collection via audit, but they've actually exceeded it by quite a handsome sum of 2.5 billion. That's an important point because the practical tip here is that each state-level customs branch are actually given certain KPIs to meet. So, we have seen instances whereby a huge multinational company under audit, and the audit could be very aggressive, and that's because customs are pressured to collect and to meet their KPIs. Now, in this slide, you will see a quick summary of key laws that underpins the power of the Royal Malaysian Customs Department in conducting customs audit. The key and pivotal act here to focus on is the Customs Act 1967. And the rest are very subject matter specific. Things to look out for when you think about all these laws are essentially these powers are sources of law that grants customs the power to audit, to issue bill of demand or notice of assessment, to impose certain penalties in the event of non-compliances, or to even come knocking on the doors to collect and to seize certain documents. Now, what we thought would be helpful for us to do is to provide this screenshot of customs topics. So if you're a trade compliance officer or a legal counsel in a company which has a lot of trade considerations, this serves as a very good snapshot to get a sense as to what are the hot topics, what are the key potential considerations that you may want to think of in the capacity of a position. Now, what we've done here are the items in red are denoted in red because these are hot topics from a customs audit lens. So over the many years of practice, classification and compliance with customs facilities, these two remains the hot audit topics, right? Timeless topics. So something for the business to think about if you do have such considerations within your business plan. Other topics that you would also see in the context of customs audit are valuation topics, as well as origin related topics. The bucket right at the bottom, right, the red bucket, relates to sales and service tax. It's another potential hot topic that we're seeing rearing its head. And that's really because the grace period for compliance with the sales and service tax has already passed when it was introduced back in 2018. So there's a lot of enforcement action on this front. Now, what we thought might be helpful for us to do in this particular session is to sort of share with you the key components that underpins a customs audit process. So here, the first stage, you will see a notice of audit being issued, right? It could be an audit by way of a field audit or a desk audit. And we'll talk about some of the differences later. Second component relates to the notice of audit findings. So essentially, once an audit has been completed and there are certain results, they will issue an audit findings that will tell you a couple of information. And the final phase in respect of a customs audit process is the issuance of a bill of demand. And that's where the liability to pay crystallizes. Now, moving on to the first component of a customs audit process, there are two types of audit, as we mentioned earlier. Desk audit is essentially an audit which is done remotely. So it could be a request by an email, whereby the officer said, hey, could you please email or send to my office certain documents. There are certain instances where a taxpayer may be required to attend an interview at the customs office, but it's rare and far and few in between. But there's a possibility of that happening. And you do have to think about, the mode of submission. Officers may say email, but sometimes if documents are quite voluminous, then you may want to submit them physically at the office. Now, the second type of audit is a field audit. And, it's essentially an audit whereby the officers come knocking on the doors and say, we want to audit you, produce documents now, you are under audit. Typically, in most instances, they would email a particular company and say, we will be auditing you. But there is also instances whereby it will be a dawn rate type of audit where they will come unannounced. Same thing as well, you do have to think about what documents they may request and provide them accordingly. Now, practical tip to think about here is, if you're a business managing a particular audit, always ask customs officer, right? What exactly are you looking for? Because that typically is a common pitfall that we see businesses when they manage customs audit. And the second practical tip to think about also is that typically for your audit, the request is underpinned by a particular timeline to get clarification, as to when the officer needs it. Now, the next component relates to a notice of audit findings. So typically, just an overview, typically an audit would cover a period of 3 years. Under law, they could actually go up to 6 years, but in practice, it's always 3 years. When they issue the audit of findings notice, the letter should typically state the amount of shortfall, that's the number, and also the legal basis in which they've arrived at the shortfall. Depending on the value at stake, right? If it's a very significant value, above 1 million, for example, the customs officer would typically then organize a roundtable discussion. So they could then discuss the audit findings with you. Key tip here to think about is that in most encounters with customs officer, we find that they don't typically tell you how they arrive at the number. As a business, if you're someone who's managing the customs audit, always ask the customs authority, how did you arrive at the number? And more often than not, they would be able to provide you with some sort of computation table for that. Bear in mind that for a notice of audit findings, you are typically given 7 days to respond to it, but there's also avenue to ask for an extension of time. Now, the final component of a customs audit relates to a bill of demand. So in a case where you either concede to the notice of audit finding or you have failed to respond to the notice of audit findings, then customs will proceed to issue a bill of demand. Now, timeline-wise is quite sensitive because they will typically give you 14 days, but again, you could always ask for an extension. You just have to manage it upfront. If the business decides to sort of agree to the bill of demand, management says, we agree with it, it is an error on our part, we'll accept it. You do have to think about whether or not if the amount stated in the bill of demand has an impact on your books. Sometimes if a bill of demand is issued towards the end of financial year, your finance controller may then say, actually, can we sort of delay the payment? Think about various options that may be available to the business. For example, you could ask for payment by installment. That's possible. You have to negotiate that with the customs authority. Now, if the business sort of disagrees and say, no, we're going to fight the bill of demand, there are some appeal options available, which Jason will cover later. But bear in mind, some of the options will actually require you to sort of pay the sum first before you could appeal. So it's a pay first, appeal later type of approach. So just bear in mind, some of the options may not be suitable depending on your financial position. Now, practical tip here is that typically when the business thinks about, making a decision whether to accept or not to accept, they will only look at the amount in the bill of demand. But you will also have to think about, if I accept the bill of demand, what other exposures may come from it. So one key component is compound. If the offense is compoundable, then typically customs will issue a compound offer letter. It could go, for example, up to RM250,000, depending on the type of offense and depending on the factors at play. Bear in mind that certain offenses may also trigger anti-money laundering risk, and that's important because under Malaysian anti-money laundering laws, there are certain rights that customs could activate. So rights to sort of freeze your bank account, to ban the directors from traveling, and etc. So that really sums up sort of nuts and bolts of what underpins a customs audit. Now, in the next segment of the presentation, what we thought would be helpful for us to sort of do is to go through a case study to bring some of the key issues we've discussed earlier to life. And the hero of the story, as you can see, is Hiro-san. Hiro-san is an employee of a Japanese multinational company with multiple factories, various business segments within Malaysia. Now, Hiro-san is in charge of trade compliance affairs of the Malaysian subsidiaries. Hiro-san could be a trade compliance officer, or could be a legal counsel with a specialist knowledge in trade, or could even be an indirect tax manager. So Hiro-san is essentially someone who looks after trade compliance affairs in Malaysia. Now, in this particular case study, Hiro-san was actually instructed by management to close down one of the many factories owned by the Japanese MNC in Malaysia. And that's quite a common trend because, if you've in the course of your corporate exercise, you may go through certain rationalization exercise to close down certain businesses that are redundant, or it could be cost optimization exercise because of the impact of COVID on the books of the company. Now, as part of the closure exercise, the company had to surrender certain trade licenses, and a closure audit was triggered. So when we talk about trade license, think about it in the context of your business. It could be a licensed manufacturing warehouse, it could be a bonded warehouse, or it could be a sales and duty discretionary exemption granted by the government to you. These will all generally trigger certain closure audit. Now, as a result of the audit, the customs have found certain non-compliances, and they've issued a bill of demand as part of the closure audit. The company said, we're going to concede, we're going to pay all the demanded sum in one lump sum. Now, many months later, Hiro-san was having breakfast at his desk, and the customs officer came unannounced for a field audit on other sister companies that weren't audited previously. So this is quite logical because, you think about it from this point of view. Hiro-san looks after multiple companies in Malaysia. If there was one error in non-compliance that was propounded by the fact that, Hiro-san has actually missed out a particular topic, then customs officer would typically look at the business in a broader context to say, fine, there's one non-compliance with company A. Company A has affiliates, company B, company C, company D. The same mistake may also be propelled in the other companies. Now, in that particular case, during the dawn raid exercise, the receptionist initially stopped the officers and asked for COVID test clearance. And it's actually quite common because, a lot of companies would typically have certain COVID clearance processes. And that really underpins the importance of, even the receptionist needs to be trained as part of any audit process that a company may roll out. So in that case, Hiro-san panicked, and he complied and shared all documents requested by the customs authority. And that really, again, underpins how a process could be, audit process can be quite stressful, especially if Hiro-san has a report that he needs to rush to his management on that day itself. So in that case, customs officer said, we've done the audit and we found certain non-compliances. And the company didn't quite agree with the bill of demand. Hiro-san, as part of the due diligence exercise, then has detected certain non-compliances that customs authority did not actually raise. So the question for this case study is, what should Hiro-san do? Now, we'll break up the various segments of the case study into a few topics. The first topic we want to cover is essentially key audit trends that we are seeing in Malaysia. Now, what we are seeing in Malaysia is essentially an increasingly aggressive audits being conducted by customs officers. So For example, they've set a 40.7 billion collection target, but they've well exceeded that. That really shows that the officers have actually been putting the hours, time, and resources in ensuring that audits are rolled out on companies operating within Malaysia. We are also seeing something, what we are coining as a domino effect. So a domino effect, what we are seeing is essentially one from a topic perspective. So we've got clients who are being audited for one topic, topic A. But upon closure of the audit on topic A, they then went on to topic B and topic C, right? And it's essentially a domino effect whereby one non-compliance has led to other audits as well. The other aspect of the domino effect is what we mentioned earlier, right? Sister companies being audited, whereby the first company being audited, there were certain non-compliances, customs officers then move the target to other affiliate companies within Malaysia. Another trend we are seeing is also multiple audits being conducted by different departments within the Royal Malaysian Customs Department as well. So example would be, a client being audited by the audit department. Then subsequently down the road, they were audited by the Sales and Service Tax Department. And a couple of months down the road, they were audited by the Customs Facilitation Department. So that really underpins the observation that Jason has raised earlier, that audit has been quite aggressive, and the Malaysian government is serious in wanting to collect the collection targets set. Now, the fourth trend that we are seeing here relates to cross-agency collaboration. So what we've seen is an example of what we've seen is, during the COVID era, you would see collaboration between the immigration department, police, the customs department, as well as the tax authorities, where they sort of go to a particular company and say, we want to audit you. It's primarily driven by COVID compliance considerations, but in that case, it doesn't discount the possibility that they may also audit you on their respective jurisdictions. So customs on customs topic, immigration on employment related topics. Now, another point we wanted to raise is that the aggression of audits is also reflected in the fact that in certain audits, we are seeing authorities activating certain personal liability that's tagged onto directors. So it could be a case where they say, we want to name the director as one of the personal liable in the event of a lawsuit. That's not typically the case, but that we are seeing a trend where directors are being dragged into audit processes as well. Now, in terms of hot topic, we've mentioned closure audits. That's one. Compliance with exemption facilities, we've mentioned that as well. It's another hot topic. It's a very common mistake we see among businesses. Classification, we've mentioned as well. Sales and service tax, we've mentioned as well. The last topic under the second bucket relates to origin verification. It's a topic that has not caught up in Malaysia yet, but in other countries that we have experienced in, we are seeing an increasing audit in origin verification, and businesses are also asking a lot of questions relating to origin verification. Now, in case helpful from an industry point of view, the automotive industry, we are seeing topics revolving around classification evaluation. In the steel and electronic and electrical industry, we are seeing, focus on compliance with exemption facilities. And in the FMCG space, classification and sales and service tax issues are quite hot topics for these industries. So moving on to the next segment, in managing dawn rate. So you will recall it was a scene whereby Hero was having his breakfast at the desk, and then officers come and announce for a field audit. And Hero panicked and then shared all the documents. Now, a lot of the bigger businesses, multinational companies especially, you would already have some sort of dawn rate training that would sort of equip your employees in managing dawn rate. Now, the things that you see on the slide here today will not deviate from that. But what we wanted to share is a bit more of a customs-focused considerations that you may want to take into account and walk through them very quickly. Now, the first step is if customs authority come knocking on your door, always involve legal, your internal legal team. That's because the legal team will have to sort of manage any potential exposure that may arise from a particular customs audit. And the legal team could also activate external counsels, especially given that customs audit is quite a specialist topic. Second step is to always stay polite. Check the IDs of the officer because it may be a scam, may not be a scam. You just have to check that they are legitimately officers. The employee on the ground managing the audit could also do a very quick Google check and make sure that the officer that is appearing before your premises appear on the directory of the customs officer. Now, the first point here we state here is to stay polite and cooperative. That's because, you know, in our experience managing customs audit, typically customs officers in Malaysia, there is a certain degree of personality involved. Officers will say, you know, like, it's my right to audit, you better comply. Receptionist, why are you stopping me from coming into your offices, right? If you stop us again, we could actually issue a warrant to break into your premises. So please do comply. So bear in mind that you do have to manage certain personalities, especially with customs officers who can be very aggressive and quite authoritative. Now, the third point here relates to managing your officers. It's always a good idea to sort of escort them to the meeting room. Don't let them wander around the office so that, you know, because there's always a possibility that they may snoop around, hover around the other employees, and they may catch hold of any hallway discussions that may contain certain information detrimental to business. So always contain them within a room. That's something for the business to note. Now, the fourth point relates to responding to any requests or questions raised by the officer. Typically, if the legal counsel is not there yet, try not to answer any question. And really, that's based on experience where we've dealt with an audit, but the business has sort of say, you know, a particular story A to the officer. And the lawyers then came in only very much later in the audit process. So when the lawyers then analyzed the issue and come up with a narrative, story B, and we put forward story B to the customs officer. Customs officer, we've seen instances whereby they've said, no, but that wasn't the story you told us from the outset. So this underpins the importance for the employee and the Crown managing the audit to not answer any question, because you've got to make sure that your defense strategy is right from the get-go. Now, the fifth point relates to record keeping. So whatever information that the business provides to the customs officer, it's always prudent for you to sort of get a detailed list. You know, if you've got K1 forms, how many K1 forms and which K1 forms, what period. Record information as detailed as possible, because typically you would then bring it back to the management and say, these were the documents requested, these were what we provided to the customs officer. And based on that information, the management could then sort of think about what are the potential issues that the customs authorities may be looking at. And that will also help you sort of form your defense strategy moving forward. And the last point here, it's also ties back to the recording aspect of things. Any question has been posed, comments that has been made, or certain gesture or behavior that you may have observed during the course of interaction with the officer, reduce them into writing. That's helpful because management will not be there. Management will be seated in Japan, in Hiro-san's case. This detailed report will help management get as full of a flavor as possible in respect of the customs audit. So I'll pause there and see if Jason, do you have anything to add to this particular slide?
Yes, I do. I think I would like to emphasize the importance of point number 1 on legal contact. The trend that we are seeing very often when it comes to clients is that they are very fearful somehow of, in some ways, offending the authorities and making things worse if they were to ask lawyers to come in and help. Really, if you think about it, it's, I mean, it's understandable that you don't want to make things worse, but the authorities are in there, since we have covered earlier, with the goal of trying to see whether or not there is any non-compliance whatsoever which may assist them towards their collection goals. So how else do you think that things can be worse if they have already found, let's say, 10 number of non-compliances? Will offending them in any ways increase that to 12? It's the rationale behind offending authorities is one that doesn't make a lot of sense and actually holds back quite a number of taxpayers, especially when they don't engage the lawyers early on. Now, what do we see then? Very often, instead, they will reach out to consultants who can be very helpful in compliance-related situations, right? Where you need to get things done based on the requirements of the law. Consultants will be able to assist. Now, if consultants were to come in during an audit or a dawn raid kind of situation, a more diplomatic approach would be adopted. right? And clients would then typically think, yeah, I really would only want to engage a lawyer when matters become clearly litigious. Now, I want to make it very, very clear to everyone attending this session that this is actually a mistake. You absolutely should not adopt that mentality. Lawyers, in fact, for customs type cases, more so than income tax type cases, are needed upfront, and for a number of reasons. But I would just like to emphasize one point, which is strategy, right? You need the lawyers to be there to implement the strategy upfront. What do I mean by that? You need to make sure that the investigation, first and foremost, is well managed from a litigation risk management perspective, right? So we need to know what is the nature of the documents that you are actually sharing with the officers, whether or not there are any privileged documents that you may potentially be exposing, and formulating clear and accurate responses to the customs authorities. In addition, the lawyers will be able to ensure that when we share facts, right, we take extra care to especially not speculate in facts if we cannot recall them, volunteer a certain amount of information when it's not specifically requested, or even sign anything in the absence of a lawyer or even an internal counsel who will say, yeah, you can go ahead and sign that document. Particularly for example, MNCs, what we see as well is that since a dawn raid happens very, very suddenly, and someone like Hiro-san will be caught off guard essentially, how would he be able to organize a response? He will need a team. So an email group really should be would be recommended. You'll be setting up a secure channel of communications. Another example is setting up a data room where lawyers are very familiar with. Immediately, a secure data room will be set up so that only internal response teams will be able to have access to the documentation, and basically organize the documents in such a way where we'll be able to provide a robust and quick response. So being organized always pays off, right? Now, if you can move on to the next slide, please. I'd like to cover this because it's a nice segue to the next point, which is mapping out the key avenues, right? Generally, lawyers will be able to assess the merits of the customs case. They'll be able to implement all forms of approaches when dealing with the customs. This is the reason why engaging a lawyer upfront is so important, because you will see on the screen right now the 6 relevant options available. If you engage a lawyer, the lawyer will be able to advise you on all the relevant options, whether it's by negotiations, you want to set aside the bill of demand, obtaining a stay order to prevent upfront payment of taxes. All of this, right, can be determined relatively early on, the moment you get audited or raided by the customs authorities. So what we can assist, not just us, but any lawyers who are familiar with customs and trade, they can present these key avenues very, very early on to the clients, right? And actually really compel the client in Hiro-san's position to do something which he typically would not like to do, right? And typically, if you engage a consultant who are more compliant minded, would not advise you to do, which is to consider the worst case scenario. Okay, so what if the customs actually forces us to a corner and we have to litigate? Because it may happen, right? And if consultants can't assist with the litigation and their assistance is actually premised on helping the clients to achieve a positive outcome, right? By the time you're aware that litigation is a possibility, it would have already been too late, because the facts would have already been presented, the documents would have already been shared, the responses would have already been drafted and conveyed to the customs authorities. So this is the reason why engaging the lawyer upfront as early as possible is particularly important, right? Lawyers are there to be able to steer, to manage the key facts based on the worst case scenario assumption that in the event that we have to litigate. And in addition, what we can also do is to highlight and put into very, very clear focus points of the customs unreasonableness, right, which is particularly helpful when litigation cannot be avoided. And I would like to put this particular point in focus in terms of steering the key facts by way of an example, a real life example recently. If you can move on to the next slide, please. So we represented AIM. I'll just call this client AIM. this is actually a GST case, right? They were actually subject to a field audit as per the Mr. Hero example earlier. So they reached out to us actually very early on. So we managed the audit from the get-go, and actually from the background, we didn't front the particular discussions with the authorities, but we managed from the background. We assisted with all the responses. We highlighted the main key points to be highlighted during the meetings and discussions, and we assisted the client with crafting the responses. So the facts are actually relatively straightforward. It's a GST zero rated issue, right? Taxpayer was actually a call center service provider for a multinational who actually made zero rated GST supplies as defined under the zero rated order back then in the GST before the repeal. So what the customs sought to do was to claim that some services, when the call center service was actually performing its service, it wasn't performing a service for its client, which is one of its related parties, but rather it is actually performing services to the customers in Malaysia who actually made the call to the customer care center, and therefore you're not allowed to rely on a zero rated order. So during the entire process, because we were there, what we could see, because we have the experience of litigating various similar cases, their strategy and arguments became very, very clear. So because we have had the experience and we know the relevant legal provisions which they are going to rely upon and what facts they need to rely upon, we were able to extract the facts which are in favor of us, right? So we steered the issues towards the direction and the key facts that we wanted to highlight in view and in anticipation of a potential litigation. So this is at point number 2, right? During the meetings and roundtables, we managed to get this all out at that stage. Now, by the time it goes to the next stage, which is the DG's review, and then we had to resubmit for the DG's review again, in which eventually they rejected, right, our claims, and a bill of demand was issued. All the key facts were already in play. So in other words, we already anticipated that this was the outcome because we knew, right? The client went in with their eyes wide open under no pretenses that this can be resolved amicably. And since all the key facts are already in place, we already knew what was a strategy that they were going to adopt. We only had to execute the plan. So we argued the case based on the facts, which we managed and introduced during the meetings, right, and during the entire audit process. And since we steered it towards highlighting the unreasonableness of the customs, we put into place certain communications which extracted more of the customs unreasonableness during the entire audit process. And eventually, really the rest was history, right? At point number 8, they lost at the Customs Tribunal and they lost at the High Court as well. So the point really here is this: if we can go to slide 25, next slide, please. Using the example that I gave earlier in relation to the AIM case, right? When we were there and advising them, we assisted them with trying to understand what the total exposure was at stake. And this is something which actually lawyers will be able to provide a bird's eye view. You understand that actually it's not just monetary exposure, there are certain non-financial stakes as well, right? And really lawyers would be quite well placed to assist, to help you take the steps and trying to mitigate and prevent enforcement risks against taxpayers, right? Especially directors, right? So directors' liabilities, travel bans, all these are all relevant concerns as well, not just the ultimate monetary amounts. Second, we typically will not treat them as just going through the process. When we talk about managing audit and timelines, we are essentially arranging the chess pieces, right? It's not just going through the motions. As long as you have a well-strategized, a robust, coherent chain of audit correspondence, right? You will get an upper hand, right? And we will know how to manage it accordingly. Third, we will also be able to help lawyers actually will also be able to actually assess the likelihood of success in the event that you have to litigate. Now, why is this important? It's because it will inform you of the strategy that you want to adopt. If the lawyers are of the view that maybe you don't really have a good chance of success, then maybe the lawyer will point you towards the quantum that is involved, right? If the quantum is too big, then should you still try to get some other necessary reliefs? Should you try nevertheless, so that you don't have to receive such a huge impact, even if your case is not that strong? Fourth, and this is really something the consultants will be able to do, but following from assessment of the likelihood of success, if you think that the likelihood isn't that strong, that the law really is not on your side, or the facts are not really on your side, you can use alternative means to try to put pressure on the customs. You can mobilize connections on industry associations, investment promotion agencies, etc. Right. And a last point would be to identify the chain of command. And this is particularly important because when we need to strategize up front and we need to coordinate the responses, who should be providing the response, right? Like Kevin mentioned earlier, would it be a direct tax person who might be responsible for the trade-related issues, or is it someone else, right? You really need to identify the relevant individuals to clear the communications which have been drafted by the lawyers, and assign a key person to actually front the communications with the RMCB. Now, moving on to the next slide, and I will just move on very, very quickly. Since we use the example of Mr. Hiro-san, right? I'd say that a hero can only do so much, right? You will get very stressed out, right? In the example that Kelvin went through, obviously Mr. Hiro-san was very, very stressed out, right? But there's no point stressing over things that you have no control over, right? In this case, if you're dealing with stubborn authorities, people that you can't negotiate with, like, is there a point stressing over them? Actually, what's more important is for you to deal with it like how you deal with things that you can't control, like natural disasters, right? You plan ahead. You perform health checks, readiness status. If there is an ongoing audit, you assess the exposure to inform you of the relevant strategies. And with all the pros and cons, all the information on the table, the likelihood of success in the event that you have to litigate if it goes south, you determine a strategy and then you execute. Now, one additional point that I'd like to add, which actually segues very nicely to WALIT, is the voluntary disclosure and amnesty program. Now, this actually may affect your strategy. So with that, I will pass it over to WALIT.
Right. On this section, I'll be sharing to you about the voluntary disclosure and amnesty program, which the Malaysian Custom has recently implemented. And in fact, this is actually quite an interesting program because some of you may know that Malaysia actually has no dedicated platform for voluntary disclosure. And I also wanted to point out that back in 2018, a similar program was implemented, but back then it was more targeted towards direct taxes. Now, on this slide here is an overview of this voluntary disclosure amnesty program, short form VA program. So you can see on the left here, there are actually two mutually exclusive options or sort of sub-programs under here. And the first one will be the voluntary disclosure program. This is more for disclosure on non-compliances, which is still not known or not discovered by the Malaysian Custom. And the second one will be the amnesty program, and it is for non-compliances where the custom has already conducted an audit and also issued a bill of demand. So the key here is actually the bill of demand. In terms of scope, this program is targeted for indirect taxes, and on the slide itself, we have set out all the indirect taxes that will be covered under this. And in terms of timeline, this program will run for about 9 months in 2 different phases. The first phase will run from 1st of January to 30th of June, and the second one will start from 1st of July all the way to 30th of September. And today is actually 7th of April, meaning to say we are about 2/3 into the phase 1 of the program already. And the main difference here is that usually the incentive being offered under phase 1 will be half during phase 2, and these are general circumstances. And on the next slides here, I would like to share a quick summary on the incentive being offered under the VA program. And if you look on the first one, there will be the tax remission. Generally, there will be a 30% tax remission if you were to participate in the voluntary disclosure program during phase 1. And for the amnesty program, that will be 10%. As mentioned earlier, if you were to go on to phase 2 and all these instances, in terms of the tax remission will be generally halved. And in terms of penalty remission, it will be 100% penalty remission for phase 1 and 50% for phase 2. And moving on, the third one will be a compound amount. The custom will issue a compound amount of either 500 ringgit or 1,000 ringgit, depending on the amount of taxes or shortfall that's payable under this program. You may note that this compound amount here is actually quite nominal, because as a matter of law, usually the compound amount that's imposed by custom is 50% of the maximum fine. So for example, if the maximum fine for a certain offense is 50,000 ringgit, custom will actually issue 25,000 ringgit of compound. But over here it's 500 or 1,000, which is quite nominal. And lastly, it is the promise for an audit immunity. There are two types of immunity here actually. The first one will be a no audit for any activity and period disclosed. And the second one will be a 1-year general audit immunity from the date 1st October 2020, provided that the disclosure is done in good faith and there's also no elements of fraud. Now, jumping back into our case study, the question here would be, so on the next slide here, I would like to invite everyone back into our case study with Hero. The question here would then be, should Hero recommend this VA program to his company? It might seem like the answer is quite straightforward given all the incentive, but we would like to pause Hero here or anyone who's thinking to participate in the VA program to think about a few strategic points or key consideration. So on the next slide here, we would like to share about 3 key considerations that's quite important. The first one will be about the audit risk that's being promised. Based on the previous program that happened back in 2018 for the direct taxes, there were some companies who have participated in the program, but yet they still got audited after that. Meaning to say, government might say, yes, we will offer you audit immunity, but at the end of the day, they'll come and audit you, and there's really nothing much that you could do. Further, there's also a possibility that custom may retain a database of everyone who have participated in this VA program, which may imply that you have a propensity to not comply. And we can't tell for sure whether custom would share this with other governmental authorities such as the IRB. Now, on the second point here is more relevant if you are interested in participating in the amnesty program. This is to really take a step back and assess the likelihood of success for your existing dispute. And the point here is that, for example, if you have a huge exposure, you have a bill of demand that's like asking for 10 million ringgit, given the size of exposure, your goal here would then is to mitigate the exposure and then to, and if let's say you do feel that you have a strong argument against the audit finding, the 10% tax remission that is being offered under the amnesty program during phase 1 would actually not be that not that attractive anymore. So this is to say, if let's say after assessing your own case, your argument, you feel that maybe you have 60% to 70% likelihood of succeeding your appeal against custom or the audit finding, you might say that it is actually better for me and my company to take the risk and to roll the dice and go ahead with the appeal. And the last point here, this is actually something that many businesses tend to miss out based on our experience. We all know that generally, custom can demand for a shortfall of taxes up to 6 years. However, in practice, the custom audit coverage period will be around 3 years, generally be 3 years. And we have to also take into account that if you were to participate in the VA program, custom will give you 1 year general audit immunity. Then finally, the question would then be, how many years should a business look behind in order to decide on the amount that they should be disclosing under the VA program? Of course, the answer here would largely depend on different businesses' risk appetite, but this is something that we really have to point out because it is more of a strategic point that all the companies should definitely consider and carefully consider when deciding whether to participate and how much they should be disclosing under the VA program. And that is all for my presentation about the VA program. Now I'll pass the floor back to Kelvin.
Thanks, Willie. So we've got a couple of questions in the live session. We've got about 6 minutes left, so we'll try to take as many questions as possible. So I guess there were some questions relating to product classification. Goes along, can customs audit the request for products for classification, and there was a tag-on question to say, if the audit is on classification, customs officers will handle official classification or the business will handle the classification. If both submit for classification, what are the repercussions? So maybe to answer the first question, yes, customs authority do have powers to challenge the classification adopted. Essentially, any topic that will affect your exposure in terms of payment of customs duties or any laws that we mentioned, we have a screenshot earlier, the laws that they enforce, they can come after you, classification included. Now, in the event of classification, typically what will happen is the customs at the border will say, no, these are not chocolate. These are, something else. These are coffee, not chocolate. Then what will happen is that the business has to pay under protest at the border. Say, we don't agree with the classification. We're going to pay because we need to clear the goods to sell to somebody else. We'll pay under protest. The business will then need to apply for a classification ruling. And this is where you go to the customs headquarters to apply for an official ruling. And headquarters, the technical division, will decide on the ruling. With that ruling, if you are right, you then bring it back to the customs authority at the border and say, hey, I'm right, you're wrong. Customs officers will not apply for the ruling internally. So you actually have to go and apply for a ruling if you want to defend your own position. So 2 questions answered on classification. There was a question relating to rules of origin. Is there a document from the Malaysian government website where we can find the rules of origin in Malaysia? The answer is yes, but no. Yes, but no, because yes, the Ministry of International Trade and Industry actually maintains all the free trade agreement and the text, including the rules of origin in their website. It's on their website. But the no is because we have seen instances whereby that particular ministry has uploaded the wrong version of the rules of origin onto the website. So you will always have to check with a lawyer, I guess. There are certain, the rules of origin are gazetted as a matter of law. There are 2 other questions relating to the dawn rate aspect of things. So it goes like this. You mentioned that we should not allow the officers to wander around the office during a raid. In the first place, do the customs officer have any right to go around an office and select the records and files which they wish to take back or review on the spot? Answer is yes. So if you recall, there were a series of laws that we make reference to, Customs Act being the most important. Under the Customs Act, customs authorities do have very wide-ranging powers to come and audit you, seize certain documents, and to seize computers as well. So any information that affects your compliance with customs-related topics, they have rights to sort of access and activate those powers. So the answer, I guess, to that is yes, they do have right to conduct a dawn raid on your business. The next question relating to dawn raid is, during a dawn raid, we will not have our lawyers on standby to manage the officer. In this case, we cannot avoid answering questions posed by the customs officer, ? Under such circumstances, how should we deal with the officers present in office? Now, yes, in certain situations, you may not have a lawyer on standby or an in-house counsel on standby. Now, the way we would recommend managing this scenario is that simple questions as to who is in charge of compliance or record, answer them, because there will be no skin off the company's back. But more critical questions relating to have you been selling the goods to the government, because the exemption is for the government. If it's straightforward answer them. Try not to answer questions which are difficult, whereby they say, oh, we noticed that there were certain non-compliances, can you please explain? Where it requires a bit of discretion, I guess, in answering them. Try not to answer them. Response that the business can put forward is say, oh, I'm not very sure. Another person is managing this one, and I need to consult my colleague. Could you please give me time to consult? I'll get back to you. Jot down the question, decide internally how you want to deal with that question, then go back to the officers once you have a response. Jason, anything to add on the dawn raid?
Yeah, I do actually. So if you recall earlier, I mentioned about the health checks, right? The health checks doesn't pertain just to internal compliance, but also do you have in place measures, the telephone numbers and contact details of the relevant lawyers relevant persons, in fact, that you should reach out to in the event that you actually raided, right? So that's why it's very helpful for you to have Kelvin's phone number handy, right? So you have his contact detail. If there is any issues, you panic and you don't know what to do, you're a hero, you don't know what to do, you pick up the phone and you call your lawyer. Or you call Kelvin in this instance, right? That's number one. Number two, what if while the lawyer is on the way, the officers are actually going through, rummaging through all your documents, reading through all your stuff. And for this, I can actually give perhaps one very good practical example, something that happened a couple of years ago, where one of the client was actually raided, and they were raided at 7 a.m. in the morning. So the officers were waiting around at about 6:30 in the morning. And then by 7 o'clock, they immediately went to the gate, and they basically just stood in front of the gate, something like 15 or 20 of them, right? For a relatively small office. And by then, the moment the first employee came in to open the door and they saw the officers all gathering outside the premises, obviously she kind of panicked, the employee kind of panicked, but they already have in place the steps that they needed to take, because again, hero in this instance actually did a proper health check. They have all the relevant phone numbers, the contact details. They escalated based on a very specific chain, right? A chain of command. It went up straight to the legal counsel, and the legal counsel immediately reached out to us. We were then there by, I think, 7:45, right? When the door opened at 7 o'clock, we were there by 7:45. And essentially, we immediately implemented our usual strategy, right? There are a lot of strategies that we implement that it would not be, I wouldn't have enough time to share it today, but put simply, we marshaled them into a separate place. We knew how to deal with them. We allowed the officers to be comfortable. We sought what they were looking for. We isolated the documents that we shouldn't be sharing with them. There are specific methodologies in which we employed to try to do that, and essentially made the officers happy enough, right? And not have them just walk throughout the entire office, seizing computers, etc., etc. So those are some examples of what we have done. But of course, there are some other quite bad examples as well. Like another really bad example is when you have insider information. Someone from the inside actually reveals information to the customs. The moment they raid, immediately when they open the door, only one officer entered into the office, and they beelined towards one cupboard for one file, and they extracted that one file, right? So that's a slightly different scenario. But generally speaking, if you call the lawyer and you have in place all the SOPs that you need to take, you should be fine, right? The lawyers will know how to manage it for you.
Yeah, thanks, Jason. I think there's one last question. There are quite a lot of questions, and bearing in mind that we're already 3 minutes past the hour, just one last question, Jason, it was raised. Are communications with Wong and Partners legally privileged or subject to disclosure to authorities or courts?
They are privileged.
Okay. Thank you, Jason. So I think I'll pass it over to Yaiko to close off this session. Thank you very much, everyone.
Okay, please join me in thanking our speakers, Jason, Kelvin, and Waylit, for an excellent discussion on Malaysia updates and developments. We hope that you found this session informative and relevant for your organization's operations. For more information, or if you'd like to discuss further, please do reach out to us, Jason, Kelvin, and Waylit. On behalf of Baker McKenzie and the IMT Group, thank you for joining today's webinar. We would appreciate your feedback through a short survey that will pop up on your screen after this session. The next webinar in this series will be held in June, and we will focus on China. We look forward to having you at our succeeding sessions. Goodbye for now, and have a great rest of the day ahead. Thank you, and bye-bye.
Thank you, everyone.
Thank you, everyone.
Thank you.